here in the courtroom today. If I could have counsel.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thomas on behalf of the defendant, William Croll.
So for the record, I did receive a victim impact statement from Lake State Railway. I did receive a number of letters on behalf of Mr. Croll. I had a chance to review all of those letters prior to the hearing today. And Mr. Thompson, did you want those attached to the pre-sentence report?
I did, please, Your Honor.
So I will attach those. So Mr. Croll, just so you're aware, I didn't receive those. I had a chance to read them.
Thank you, Your Honor.
Mr. Thompson, are there any other additions, deletions, or corrections?
There is a small correction to the PSI, Your Honor, going to the employment section. Sorry. But it's just a typo. I think it's a typo, but when it indicates he worked for Mr. Freeman, that's to the present. That did end in October of 25, which is consistent with the next employer picking up then in October.
This says date December, but that should be October.
Yes.
Any objections to that change? So,
No.
any other corrections?
No, Your Honor.
Any challenges to the scoring?
No changes to the scoring.
Spoke to the people, have any additions, deletions, or corrections?
No.
Challenges to the scoring.
No.
Again, I did receive the written statement from Lake State. Do you have any other victims that wish to address the court today?
Jeremy Craig indicated he was going to be here to speak today, but I did not see him in the courtroom. I just want to confirm he's not on Zoom.
No.
Okay, then no.
Anything for allocution?
Your Honor, Mr. Croll really wasn't not even somebody I had ever heard of until I couldn't stop hearing about him. Just over and over and over, he was on bond. He commit more crimes, he on bond, he commits more crimes. One of the charges in here is the stalking. He continues to talk about his fiance. He did it in his district court sentencing. There is a PPO in place. Despite that, he continues to contact her. There's a new police report, and it depends on what today's sentencing is, what I'm going to do with it. But even with all that PPO in place and the no contact order, he continues to contact Marissa Pagolio. I think 37 times he has contacted her since December 6th. Despite that, knowing that the calls are recorded, he's in jail and he still makes those. The police report indicates, and I haven't reviewed those calls. The police report indicates that at times he's argumentative with her, at times he's intimidating, at times he's threatening. And she indicated that she's even been contacted by his mother. It doesn't say what those contacts are. I think there's some stuff that needs to be, he has some of her stuff and she has some of his stuff. But either way, he doesn't follow the court orders. He doesn't follow his bond conditions. I know that the recommendation is a jail sentence, but I think that a prison sentence is more appropriate. I think he would be a really good candidate for the boot camp program if he was accepted into it. You know, he's fairly young. He's got this history of, 9 misdemeanors, but until recently, he had no felonies. I don't know what happened to Mr. Croll. I've seen some of the videos of his behavior in the home. He obviously has some anger management, and this relationship that he was in and he conceives he's still in is all part of the problem because they all tie in together. The larceny, he did it with her. The breaking and entering was her neighbor's house. This has just been a series of crazy events. The police started at one point responding to a call at this house and he was digging up dead bodies in the yard is what he told them. There seems to be a substance abuse issue or mental health. I'm not really sure what's going on, but there isn't a lot of likelihood that he's going to follow those court orders, even though Marissa Pagolio has said, I don't want him to call me and I keep talking to him because I'm scared of the times he told me he's going to kill me if I don't. So they have stopped his contact to her by having to block her phone number in the jail. It's the only way we could stop it. And I think that given his long history, all the stuff that he did while on bond, I think it's appropriate to do middle prison sentence. Thank you.
Yes. One of the things you said reminded me of a question that I had when I was reading through the report. Mr. McFeely did the PSI better.
Yes, it did.
It looks like the plea was entered in this case on January 8th. And in the report, did it indicate that Mr. Croll, even after the plea was entered, was attempting to contact
That-
Jolie?
That's correct, Judge. Yeah, I stopped tracking the dates after January 20th,
Okay.
but from this, when my report was done, I don't know what he's done since that date, but up until January 20th, there was 38 times he made calls to her with making contact on 7 of them. That was from December 6th of 25 to January 20th of 26.
All right, thank you. Mr. Thompson. Yeah, Mr. Croll.
I have a few things, Your Honor. I received a letter from Mr. Kroll's mother. I'm sure the court reviewed it. I'm sure the court can empathize with her position and her statements where she, acknowledges what occurred, but she also offers and assures the court that she is strong family support for Mr. Kroll. I think that's important as the court looks at its options here and weighs what to do. I think if the court went down the road of prison, as Ms. Koch is suggesting, that it would be appropriate to allow him to do boot camp. However, I do want to advocate to follow the recommendation and to impose a jail sentence. And in doing a jail sentence, I'd also ask the court to consider concurrent sentencing instead of consecutive sentencing. Mr. Kroll is a very young man. He's 25. He could have even potentially received hideout on these. That's not the offer. That's not where we're here today, but that's the kind of age he is. And it's been alluded to earlier today, young men are still developing at 25. Their brains are still developing. And Mr. Kroll is a person who made mistakes in the past, but it really did accelerate this year. And the thing that struck me in reading the PSI was when he got to the substance abuse section, methamphetamine started at 25. And I don't think it's a coincidence that that's when things did accelerate with his criminal history. That's been my observation doing this job for however long I've been doing it, in terms of methamphetamine accelerates things in people's brains. It's so destructive to our community because of that. It's hard to explain or defend some of the things that happened here, but I will say that Mr. Croll is a person, he's full of potential. He's a very bright person. He's a very hardworking person. He's a very energetic person. I think if he did get a county jail sentence, one thing that would be in front of him would be that opportunity for trustee status. I don't believe he's there yet. I'm talking to the jail, but I think that would be a strong incentive for him because of the amount of time he would earn if he were to become a trustee. Block Mr. Giulio's number. I think that relationship has proven really to be disastrous for Mr. Croll. I hope, saying it in different ways and seeing the effects of it will really drive that home. I think he intellectually understands where he's at with that case, but now he's got that situation, but now he's got to live it out every day. We all know in this job, that's the real challenge is living out the change you want to achieve in your mind. And so I do think Mr. Croll is of an age and with a support network and in circumstances that do suggest perhaps this can be a blip on the radar. Perhaps this is not his future. Perhaps this is, that really bad couple months he had in 2025, but overall he gets back on track, gets his life going. I have high hopes for Mr. Croll. I hope the court will consider concurrent sentencing here. I think these occurred very quickly. I think this is a gentleman without a felony background. And so I do think in a certain way, I look at this as a series of related transactions. Would ask the court to do the same and to oppose concurrent sentencing. Thank you.
Thank you. Mr. Croll, anything you wanted to say?
Sorry, Your Honor. I was hoping I could make it farther than this without getting emotional. Is there any chance you could just read my letter? I have 2 pages written for you.
Certainly.
Yeah, they're marked 1, 2, 3, and 4.
And is there anything else that you wanted to say, Mr. Croll, in addition to that?
Oh, yes, sir. Yes, Your Honor. Oh, I just want to stay in front of this court. An apology to Jeremy. He's a good friend. So I'm just at a loss for words, like I said. And I just want you to know with conviction that I have a lot of big goals, dreams in my life. And my mother and father know that very well, that I'm capable of achieving them. And I know it very well in my heart. And my vision for the future is never been more clear.
All right, well, Mr. Croll, again, I did read all the letters that were submitted. I read through the pre-sentence report, so I'm familiar with each of these incidents that were convicted on. There's also a lot of information in that report about your circumstances, generally, your background. So I take all of that into consideration, along with what the lawyers had to say and what you had to say through your letter there. And it's always interesting to me, and I certainly, as a parent, I feel for your mother, her letter that had a lot of impact on me, because I think we can all imagine ourselves in her position where she sees you in such a different light and knows the good qualities that you have and have experienced those. And the other people that wrote letters on your behalf and were very complimentary of you in terms of your work ethic, they all expressed surprise that you're at where you're at right now. And so that indicates to me that they all see some good qualities there and they must be there. And they're all looking at you from that perspective. And I think they're probably wondering themselves how you ended up in this spot. And from my perspective, I can appreciate their points of view on that. But I also have to look at your behavior. And going back to the time that you were in the service, the problem started almost immediately and continued. And then once you were discharged from the service, they really continued. It wasn't too long after you were discharged that you had your first charge as a civilian. So something clearly has gone awry. The charges in this case, I was really struck by the statement from the railway. I thought it was very interesting, even though it was an economic loss for them. They certainly, it disrupted their operations. It created a larger safety issue, and there were ripple effects from that. And I appreciate the statement from that, because that was something that I didn't fully appreciate, the type of effect that the theft of those materials had on their operations and in a larger sense of public safety. Your actions with regard to the stalking and the breaking and entering, it is very concerning to me that knowing that there was a personal protection order, knowing that your bond conditions prevented it, knowing that that you were making these calls because they were coming from jail. You still continue to do that even up to recently as January 20th. That indicates to me that there's a real issue with self-control here, that in light of knowing that there's going to be negative consequences from that, you continue to do it. A lack of recognition that these are court orders, that they're not optional. It's not up to you to decide whether you're going to follow them or not. You have to follow them. And just again, the fact that there was no way that this wasn't going to be discovered. And so that to me is concerning from the standpoint that I don't know that right now you're capable of following through with probation, capable of exercising self-control that's necessary to abide by the conditions of probation on your own. Because even in a jail setting where literally the jail has to stop you from being able to make that contact, that's the only way that it's stopped. You can't even do that in a jail sentence or in a jail setting where it would be easy to just not do it. You're out in the world, there isn't anything stopping you really from doing that. And so I just don't have any confidence based on the behavior that you would be able to independently, voluntarily comply with conditions of probation. And I think as a whole, looking at this situation, I think a better solution here for you than probation and local time is a prison sentence. I don't have any objection to you participating in the boot camp program. I think that might be helpful for you. It's certainly more rigorous than what we would have the resources to provide in terms of probation. And again, given the way that things have gone, I just don't have any confidence that you would be able to follow probation. And I think we would end up back here on a violation relatively quickly. So,
Your Honor, is there any chance I could speak real quick?
sure.
So to explain my calls to Marissa, when I broke up with her officially, she threatened to end her life. And that's why I called the police that day, that she disappeared, and told them about the bodies that might have been buried in the yard. And honestly, we were on good speaking terms for every one of those calls. And she told me she looked forward to those calls. And I was doing it to try and ease the pain of the separation, in honesty. And if you look at the bright side, not the dark side of maybe we yelled at each other a little bit on one or two of the calls, which is normal quarrel. It was really, we told each other we loved each other. We still wanted to get married. We were still on good terms. And I was really just trying to smoothen the transition for our separation, because we're still technically engaged, and that has come to an abrupt halt. But I just didn't want to live the rest of my life blaming myself for her ending her life, because I believe right now she's in that position, and there's nothing I can do to stop her. She lost her kid. She lost her dog. Her house just got broken into by raccoons like 2 days ago. She's sleeping in her truck. I think she's very close to ending her life, and I will blame myself if she does. That's why I made those calls, Your Honor. Thank you.
Well, again, it's not up to you to decide that you need to make those calls or it's appropriate. You weren't supposed to do it, and you did it. And again, that just continues to show me that you're going to exercise your own judgment about when you think you need to follow orders and when you don't. So it just proves my point even more what you just said. So the guidelines are 7 to 23 months and 5 to 23 months. A reasonable and appropriate sentence is 18 months in the Michigan Department of Corrections. So that's to count 1 in file 5497 for consents to 18 months to 5 years in the Michigan Department of Corrections. You have credit for 2 days served on that file.
Respectfully, when we get to the breaking and entering the building, is the court sentence here, is that concurrent then to MDOC sentences concurrent?
Correct.
Okay, I believe he'd be entitled to the 64 days as to the breaking and entering, and because that bond was not posted, look at page 1. The way I took the recommendation was there's a recommendation of no credit because of the recommendation for consecutive.
That, what he's saying is accurate, I just gotta, yes.
Yeah, it's Mr. McFall.
If it is concurrent, yes, then he's correct. 64 days would be the credit on 5512.
So that wasn't a correction because it's dependent on what the court.
Right. So, yeah, I mean, because the court is sentencing, imposing a prison sentence, I'm not going to impose the consecutive sanction because essentially the prison sentence is time extended. Right, so that's as 5497,
Just to confirm, we're doing 18 months, 5 years credit for 2 days.
correct, on 5497. On that file. Restitution in the amount of $1,184 payable to the Crawford County Clerk to be dispersed to W Auto Parts. Crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, state cost of $68. As to file 5512, and that's the breaking and entering of intent, charge 18 months to 10 years, credit for 64 days served. On that file, a crime victims assessment of $130 and $68. On file 5513, 12 months in the Crawford County Jail with credit for 64 days served, crime victims assessment of $130 and $50 state costs. All those sentences can be served concurrent to each other. And again, the court will have no objection to boot camp. Mr. Thompson, you can provide Mr. Croll with his appellate.
So Mr. Croll, these are two sets of appellate rights.
We have to discuss the contempt.
If you initially hear you're acknowledging you receive them, this doesn't file the appeal. To file the appeal, you'd have to fill it out. If you want to request an attorney, there's a section for doing that. First time when it's due within 14 days. Yep. You kite this out either from this jail or from the prison. Start your appeal. That's what we want to do. I'll leave you with 2 of these copies. Appeal if that's what you choose to do.
Contempt.
Issue on the 5513.
Hold on one sec, Mr. Kroll.
Well, I'm just
Mr. Croll, start your case.
Okay. All right, so the contempt charges are dismissed. And I am going to decline the new case that will allow him to go to boot camp. If I charge it, it would stop him. So I'll get that decline letter done today or tomorrow so that he should be clear for boot camp.
that's all for today.
Okay, thank you.
Mr. Hamlin, are you able to hear me okay?
Morning, Judge. Yes, thank you very much.
Okay, good morning. So this is the date and time set for a sentencing hearing in this matter. I know that had a lot of back and forth on this case in terms of what procedurally was the correct thing to do. So we're ready to move forward here today. It's my intention, of course, I think based on what we discussed in the past, to sentence Mr. Fenel to probation, with the main term of that probation being that he participate in and complete the drug court program in Otsego County. And Mr. Hamlin, is that something that you're ready to go forward with and accept him into that program?
Yes, Your Honor. He was accepted last year, say around September of 25, and placed on bond conditions. I believe his attorney has a copy, and maybe the court might have a copy today as well.
Okay. And is that your understanding as well, Mr.
It is, Your Honor.
Okay. So all of that being said, Mr. Fenel, have you had a chance to go through the pre-sentence report and talk to Mr. Clagstead about it?
We reviewed it yesterday.
Okay. And Mr. Clagstead, are there any additions, deletions, or corrections?
Judge, no additions, deletions, or corrections per se. There are 2 items to talk about, but they are correct as drafted.
Okay. And are there any challenges to the guidelines?
I believe the guidelines are accurately scored, Judge.
Thank you. Ms. Cope, do the people have any conditions, deletions, or corrections?
No,
Any challenges to the scoring?
no.
Anything on behalf of the people for allocation today?
You know, I really struggle with these cases where somebody doesn't get any jail time at all when their drunk driving history is impaired 2017 and OWI 2021 and OWI 2023, and then we're back here again for another drunk driving, and his blood alcohol was, you know, double the legal limit. So I also understand that sobriety court is a very good tool. And I think it's appropriate that he get into it, because if we continue down this path, you know, he's fairly young at 31 to have this kind of criminal history. And, you know, he's headed towards prison if he doesn't kill himself or somebody else, if he continues down this path. So I would defer to the court as to what's appropriate, given the sobriety court. This court's more familiar with the sobriety court in Otsego than I am. So thank you.
First of all, Judge, if you didn't have those bond conditions, if you have a copy for you.
I did.
Okay. Judge, I wanted to start by acknowledging, I realize it's been a headache for everybody. I want to apologize to you. I want to apologize to Ms. Medler. I want to apologize to Ms. O'Rourke, Mr. Hamlin. It's never my goal to create a headache, Judge, and to the extent that I'm confident I probably did cause or contribute to miscommunication or confusion. I apologize, Judge. That's certainly not what I'm trying to do here. So I do feel that I owe you with Ms. Medler and everyone else an apology. Furthermore, Judge, I'm aware that you did extra legwork figuring this out, getting it to happen. Thank you, Judge. On a professional level, I appreciate that. As to Mr. Fenel, Judge, I think Mr. Haven did an excellent job on the PSI. I believe the scoring is accurate. As I said, I am going to ask the court to follow the recommendations. The two quick points I wanted to make about the PSI, Judge. Again, not a correction per se, but on page 3, I think it's item number 22. It discusses a probation supervision fee. It's come to my attention that that's somewhat, I guess, duplicative or redundant in the sense that Mr. Fenel will also be paying for a supervision or oversight fee to the sobriety court. In that regard, Judge, I'd ask you to strike number 22, but I believe that's essentially, it's your call. It's not mandatory.
Right, so we addressed that. I had another individual earlier that was going into waiting for, I believe, is that your position as well, Mr. Haven, that
Yeah, I've understood other defendants that have been able to waive that if they're in a treatment court.
yeah. So I'm going to strike paragraph 22 based on that. So I'm aware there's significant fees associated with supervision.
Second sort of logistical issue, Judge, as the bond conditions indicate, and as Mr. Hamlin has said, Mr. Fenel has been participating in sobriety court voluntarily since November 5th. Mr. Hamlin or Mr. Haven can correct me if I'm wrong, but my understanding is that as the sentencing judge, it's up to you, it's your discretion, whether that time participating in the program up till now could be counted towards completion of probation. And I think what makes sense to me, Judge, certainly again, it's your choice how to handle it. I would suggest just punting it to Judge Hessling. If in November of 2027, he feels as though Mr. Fenel has complied with probation, is ready to release him, great. And if he doesn't, then he won't. Rather than make that decision today, I think it makes sense to see how he does and let Judge Hessling make that decision. But ultimately, Judge, I think it is your choice.
Can I say something about that too?
You're going to have a chance, Mr. Fenel, in just a minute to tell me everything that you'd like to say.
Judge, one last thing. I know the court is sworn today. I wanted to make the point. I recognize that everybody who comes to the court for sentencing is a change agent, right? Everybody comes for sentencing ready to do different and turn their back on their past and their criminal history. I learned a few weeks ago that Mr. Fenel, because of his time in the program, was given the opportunity to face up. And I was a little bit surprised to hear that his response was no, that he felt he needed the level of responsibility, of accountability, of testing that he was currently at, and he was not ready to phase up. again, Mr. Hammond will know better than I, but my experience is that that's not a common response we get from people. When they're given the opportunity to phase up, it's usually, yeah, yesterday, right now. Through the duration of this case, just the past 5-6 months, I do feel that I have seen a shift in Mr. Fenel in terms of taking responsibility and doing something different, not doing the same thing that got him here. By all accounts, he is working the program. He's taking it seriously. It's going well. I know he's very grateful for the opportunity and everyone's contribution, literally everyone's contribution to making it work. I think that sort of shift, that recognition, that awareness is one of the things the court wants to see at this stage. And frankly, as a result of every criminal case, I'm optimistic he can successfully complete the program. That being said, if he doesn't turn things around, if he has issues, I'm very aware that he'll be dealt with accordingly in the program. Nobody gets a free pass in sobriety court, as Your Honor is obviously aware. I just hope, Judge, that this case can be a punctuation point in criminal history, and I believe he can do that. I'm optimistic. Thank you.
Thank you, Mr. Fenel.
Yeah, I'd just like to point out, I knew that what I did was wrong, and not just this instance, but in the past, and I should have learned my lesson sooner and not gotten to this point at all. But I went off to, my drinking was leading me down the wrong path, and it was going nowhere positive. And I plan to look ahead and keep my life organized and keep drinking completely out of my life. That date, I've been sober since, what was it, June 7th or 6th, I believe. I've 246 days sober and been in the program for 95 days and looking to phase up here this coming Tuesday, now that I've met that 90-day mark, and really looking forward to that accomplishment.
All right. Well, obviously, I'm very familiar with your case. I read through the report, though. I'm familiar with all the information that is in that report, including information about this offense, as well as your prior record and prior history. And one of the things about your prior history, I think you're the type of person that the treatment courts are looking for, somebody who has a genuine problem. People that don't have a problem that quit drinking and make this a one-time thing don't really get that much benefit from the treatment courts. They can sail through it and it's no problem. But they're really designed for somebody like yourself who's a repeat offender, who's demonstrated that there's an issue that they can help with. So from that standpoint, I think you're a good candidate for the program. And it is an opportunity for you to get some skills, to get some tools that can help you deal with underlying issues here that lead to the criminal behavior. And that's what's the benefit to the community. You can do that, move forward, and not reoffend, then we're all safer, we're all better off. You're better off. You're going to live a more productive life, one that's going to be more satisfying to you, and one that's not going to result in spending time in jail. So I hope that you take the program seriously. I say this to everybody who goes in, because I did preside over a sobriety court for a while, several years, and I know the people that were successful were the people who were doing it because they were sick of constantly getting in trouble and constantly being on probation. They wanted to make change in their life to move on from that. People who do it because they were ordered to, or because they got a better deal, or to avoid jail, weren't as successful. It's the people who really want to do it for themselves and end up getting through it successfully. So I hope that you go into it with that point of view, and that you successfully complete it, because again, that's the outcome we're all looking for. If you don't, however, I am going to impose some jail time. I'm going to hold that in advance. I want you to understand that if you don't make it in the sobriety court, you're violating, if you are testing positive, you come back here, there's going to be a significant jail sentence waiting for you, because at that point you will have demonstrated to me that this chance is working out, that those other things are more important to you than staying clean and staying sober. So the court is going to place you on probation for a period of 24 months. I'm not going to direct the sobriety board when they can or can't graduate you from that, discharge you successfully, but you will remain on probation here for 2 years from today. So even if you complete the sobriety court program earlier than that 2-year period, the supervision will come back here and you'll still be under probation here and under all these terms and conditions for that 2-year period. I think that's important. I think it's really encouraging that you've done well so far, while on bond and as part of the program, but I think given your history, the longer we have you on supervision here, the more assurance we have that you can stay on that path. So the court is going to sentence you to 2 years of probation. Again, with the prime term of that being participation in a successful completion of the Otsego County Treatment Court Program. We're just going to adopt as the conditions of your probation all the other terms and conditions listed in this report. The court is going to order that you serve 9 months in the Otsego County Jail with credit for 1 day served. That time to be held in advance to be served at the discretion of the court. The court is going to order restitution in the amount of $150 payable to the Crawford County Clerk to be dispersed to the prosecutor's office. Crime victims assessment of $130 for costs of $325. Reimbursement fee of reimbursement fee of $100. $68 state cost. And a fine of $500. Again, the court is striking the supervision fee. You do have the ability to seek an appeal of the sentence. Mr. Clackstead, next to you on that table are the acknowledgement of Mr. Jones' appellate rights. Have them acknowledge receipt of those, please. Mr. Hamlin, was there anything else you needed from me or anything else that you needed to state for the record today?
I have just one question for the court, Judge, because I don't have a copy of the PSI. I'm curious if there's any community service listed on there, and if the court would strike that because he is actively participating in the program and our phase requirements do have community service hours they have to complete. Probably not at the amount that's on the PSI, but I'd be curious what the court's take is on that.
Yes, if community service is part of participation in the sobriety court program, then I'll strike that. That's paragraph 9.
Thank you, Judge.
All right, Mr. Beck, anything further today?
No, no.
Does Mr. Fenel need to meet with you before you leave?
Yes, I'll meet with him and go over his probation order.
All right, Mr. Fenel, good luck to you.
Thank you.
Thank you, Judge.